What is performance guarantee under RFRP, Request for Resolution Plan? Hello friends, welcome back to our channel. Today discussion is on one of the most significant safeguard incorporated in a Request for Resolution Plan RFRP under the Insolvency and Bankruptcy Code 2016, the performance guarantee. So most professional understood EMD, that is earnest money deposit, but many fails to understand the importance of the performance guarantee. So we'll see the difference. The performance guarantee acts as a financial assurance that the successful resolution applicant will faithfully implement the approved resolution plan. So let us understand this concept through practical FAQ model, frequently asked questions. What is performance guarantee? The answer is performance guarantee is a financial security furnished by successful resolution applicant after receiving the letter of intent. Its objective is a very simple. It assures the COC, that is Committee of Creditors, that the SRA, successful resolution applicant, possess both the financial capability and the intention to implement the resolution plan exactly as approved. This is the object. So unlike EMD means earnest money deposit, which secures participation in the bidding process. EMD is for participation in the bidding process. The performance guarantee secures implementation of the resolution plan. This is the difference. Is the performance guarantee mandatory under IBC? The IBC itself does not prescribe a fixed amount of performance guarantee. However, Regulation 36B permits the Committee of Creditors to prescribe such conditions in RFRP. Accordingly, almost every modern RFRP issued by resolution professional requires the SRA, that is Successful Resolution Applicant, to furnish a performance guarantee. Therefore, the obligation arises from the approved RFRP read with the letter of intent, LOI. Why does the COC insist upon performance guarantee? The COC, Committee of Creditors, invests considerable time and resources evaluating resolution plans. So the successful resolution applicant, if latter withdraw or fail to implement the resolution plan, the entire CIRP may collapse. So to avoid this risk, the COC insists upon a substantial performance guarantee. It protects the creditors from implementation failure. Who is required to furnish the performance guarantee? Only successful resolution applicant. Qualified resolution applicants who merely participate in the bidding process are generally required to furnish EMD, earnest money deposit. All the participants in bidding, they will furnish EMD. Successful resolution applicant furnish the performance guarantee. So the obligation to provide performance guarantee arises only after issuance and acceptance of LOI, that is letter of intent. When should the performance guarantee be submitted? The answer is RFRP specifies a fixed timeline after issuance of the letter of intent. Many RFRs, request for resolution plans, require submission within a few days from the issuance of letter of intent. Failure to comply may result in cancellation of letter of intent and rejection of the resolution plan. So, in what form can the performance guarantee be furnished? RFRP generally permits either unconditional performance bank guarantee issued by scheduled commercial banks or direct remittance through RTGS, NEFT if specifically permitted. It depends. Foreign resolution applicants are usually required to furnish a bank guarantee issued by a reputed international bank having an Indian branch or appropriately backed by an Indian scheduled commercial bank. Can the EMD be adjusted against the performance guarantee? Yes. Several RFRPs permit adjustment of the EMD already deposited by the successful resolution applicant against the amount of the PBG. This avoids duplication of the security requirements. How is the amount of performance guarantee decided? The amount determined entirely by the COC while approving the RFRP. So there is no statutory formula. COC generally considers total admitted claims and enterprise value, size of the transaction, upfront payment, deferred payments, implementation risk, industry practice. So considering all this will be decided. Why is the performance guarantee usually a substantial amount? Because the implementation risk is much higher than the bidding risk. After approval of the resolution plan, employees depend on implementation. Creditors expect recovery, operational restart, and regulatory approvals commence. So therefore the financial commitment should be sufficiently significant to discourage defaults. What is the difference between EMD and performance guarantee? I already explained. Performance guarantee secures the implementation, whereas EMD applies before selection. Performance guarantee applies after selection. EMD discourages frivolous bidders. Performance guarantee protects implementation. These are the differences. What is the validity period of the performance guarantee? Most RFRPs prescribe an initial validity period, commonly 12 months. However, if implementation extends beyond the 12 months, then successful resolution applicant must renew or extend the guarantee until every obligation under the resolution plan has been discharged. Then why must the performance guarantee be renewed? Because the implementation of resolution plans often extends beyond 1 year. Deferred payments, capital expenditure, operational restructuring, and settlement of creditors. So all these activities may continue for several months. Therefore, the security must remain alive until completion of the implementation. What happens if the resolution applicant fails to renew the performance guarantee? Most RFRPs provide the failure to renew before. So they provide that failure to renew before the expiry of the commitment. See, most of the RFRPs, what they will do, that failure to renew before expiry empowers the committee of creditors to invoke the performance guarantee immediately. So just prior to expiry only they will invoke. So no further notice may be necessary if RFRP expressly provides so. Does renewal require any fresh approval of COC? Not required. Renewal is merely a continuation of original security. Fresh commercial approval is normally unnecessary unless the RFRP specifically provides otherwise. Can an affiliate furnish the performance guarantee? Yes. Many RFRPs permits affiliate to furnish the performance guarantee on behalf of the successful resolution applicant, provided appropriate declarations and undertakings are submitted in the prescribed formats. Is the performance guarantee is refundable? Yes. every payment under the resolution plan has been completed, all obligations have been discharged, and the guarantee has not been invoked, then the performance guarantee is ordinarily returned without interest after completion of the implementation period. Then does submission of performance guarantee mean that implementation has started? No. Submission merely demonstrates financial commitment. Actual implementation begins after statutory approvals and including of the approvals, statutory approvals, including approval of the resolution plan by way of adjudication authority conditions. Can the COC modify the performance guarantee requirements? Yes. Before completion of the resolution process, the COC may amend the RFRP and prescribe revised requirements subject to compliance with the IBC and CIRP regulations. Then, is the performance guarantee different from contractual performance bond? Yes. Although similar commercial purpose, the performance guarantee under RFRP, this operates with the insolvency resolution framework. So its purpose to ensure implementation of the resolution plan approved under the Insolvency and Bankruptcy Code. Can the resolution applicant challenges the requirement of the performance guarantee? Generally, once the resolution applicant voluntarily participates in the CIRP and submits the resolution plan under the terms of the RFRP, it is bound by the conditions. So courts ordinarily respect the commercial wisdom of the COC in prescribing such safeguards unless they violate the law. So the conclusion is performance guarantee is much more than a bank guarantee. So it is a confidence building mechanism. It assures creditors that the successful resolution applicant will honor its commitment. Without an effective performance guarantee mechanism, conditions may remain exposed to significant implementation risk after approval of the resolution plan. Every resolution applicant should carefully study the performance guarantee clause before submitting a resolution plan. Because once selected, these obligations become legally and commercially significant. We have two channels, RR Corporates, other channel RR Legal Talk. Please do subscribe, hit the bell icon so that you will not miss my latest videos.